Hey, thanks for stopping by. In case you're unaware, this is only a part of a larger project. Check the link in the description for a more detailed and comprehensive essay on the website. Thank you and enjoy.
Salve, mihi nomen es Phonicius Rongus. So you don't like to read? Well, that's okay. I'm gonna give you the gist. This is the evolution of the Roman court. Before 450 BCE, only rich people knew how to rule trials.
Because only rich people should control everything.
But the plebeian class of Rome demanded that there be a system that was fair and granted opportunity to all as a proper code of conduct. Thus, the 10, later 12, tables were drafted, set to be visible in all forums around the Republic. These tables were the original public code for which all law would be built upon. The first two are the only relevant ones at the moment, as they were the ones that actually detailed the structure of the court of law. Under these two, it was practiced to follow the code of leges actionis, essentially just following what was written. The plaintiff would appear and summon the defendant to court. If they denied it, they would be taken there by force. Typically, the plaintiff would be the one who brought the prosecution to the defendant, but not always. A jury of up to 75
Good God.
would then be assembled, usually made up of those who had some kind of seat in power. And speaking of seats of power, a magistrate would oversee the trial, while also appointing a iudex to preside over it. Both sides often consulted an attorney in order to argue their case. And for the next several days, they would bicker and argue in a public forum, Senate House, or sometimes even a patrician class's house. This system, known as the Iudicia Populi, was the early republic's main way of doing any kind of criminal trial. There were, however, alternatives depending on the case. One of the most well-known of these is the Quaestio de Repentundis, a system which solely formed for cases of embezzlement. Perhaps the most famous single trial in Roman history was held under this system, the trial of Gaius Verres, an ex-propraetor of Sicily who took advantage of the people and took their money for his own gain. When General Sulla carried out a military takeover of the state, he enforced a few new rules on the court system as they knew it. Sulla granted the patricians much more power than they had before, and now the Senate would make up the majority of the jury's seats. Verres was the last person to ever be judged under this system. This all fell away in 70 BCE, which happened to be the same year that Gaius Verres was going to be put to trial. But what about attorneys? Who were they for this trial? Well, I'll tell you. Verres' lawyer was a man by the name of Hortensius, and the prosecution was his rival, Cicero. Like most attorneys, both Hortensius and Cicero sought legal work as a way to jumpstart a possible political career. And Cicero had already lost multiple cases to Hortensius, who was an expert orator. So he put his all into this trial. And guess what? It turned out well for him. Verres indeed was so scared that he ended up banishing himself after Cicero had called multiple witnesses. Cicero went on to become more well known in the political sphere. Meanwhile, Hortensius nearly retired, as many people didn't want his legal work after such an embarrassing loss. A lot of things began to change as Rome transitioned from a republic to an empire. Yet for a while, the court was actually an exception. But sometime in the 3rd century CE, the Roman Empire put into place a new system: Cognitio Extraordinaria. In this system, only a magistrate would oversee the court. There was no jury, there was no judge, and the attorneys did not get to say a lot for very long. Democracy was slowly being killed off. And at this point, it had finally come for the law. As said earlier, the 12 tables were a sort of public code when they were first written. The government had very little control over the judicial parts of the law. But that, however, was no longer the case. Yet it would not be long before this tyranny came to an end. At the collapse of the Roman Empire in 476 CE, the Byzantine Empire actually reverted a few things, among those being the judicial system. While the Byzantines still had the government controlling the judicial branch, the jury was now present again alongside the judge, and ultimately, this system became the catalyst for the court we know today. With the Byzantines still kicking for a long period of time, their system spread, and it spread far. New emerging Dark Age civilizations and onward began to draw from the 12 tables. And now, here we are. While our court system may only resemble the Roman republics, you can still see a lot of similarity between the two. Ours may not have even existed without Rome's.
So I guess the plebs were good for one thing after all.